What is the timeline for applying to register a trademark? We get this question a lot. Here's a breakdown of the key events for filing a trademark application at the U.S. Patent and Trademark Office. There are really four main stages that we would like to consider: pre-filing strategy, preparing and filing the application, examination and opposition, and registration and maintenance. First, pre-filing strategy. This is what it sounds like, the strategy before filing an application, and it involves evaluating the options, what kinds of trademarks to file, and whether to do a trademark search, and what kind of search. As for what kinds of trademarks or what trademark you want to file, is it just the words, like, for example, Nike? Is it just a logo, for example, the swoosh? Or is it a combination where you might have the words and some artwork or a logo? Some of this depends on budget, some of it depends on the marks, some of it depends on what you find in your search. And is the term even distinctive enough to be a trademark? As for a search, are there conflicting marks, meaning confusingly similar marks that are already on the trademark register or that someone else has applied to register before you? What about trademarks that are being used by others that are not registered? Those are sometimes harder to find, but people who have unregistered trademarks can still have rights to oppose your application. This is where you consider the plans for the trademark, including whether you've already used it for a while or if this is a completely new trademark, and how detailed you may want your trademark search to be. How hard would it be to rebrand or change things if a conflict comes up? You can't avoid all conflicts, and no search is perfect. And some conflicts may even come up after the trademark office has approved and registered your trademark. The second step, or the second phase, is preparing and filing the application. Again, it's what it sounds like: preparing, gathering the information you need, and then filing the application. It can be done fairly quickly, assuming you have all that necessary information. This includes making sure you identify the proper owner, which can be a little trickier than you might think, listing the goods and services that are going to be claimed, which can affect the cost of the application and whether you conflict with other marks, and providing evidence and dates of first use for your trademark for certain kinds of applications. Applications are prepared electronically and they're also signed electronically. Some people ask if they should wait to start using the trademark before filing or go ahead and file. It's a good question to discuss, but filing the application before use can be very beneficial in some cases and is usually quicker when it comes to preparation. Another consideration is whether you want to file in other countries, since you may be able to take advantage of your U.S. filing date when filing in other countries. You can file directly in other countries, or in many cases, you can file through a system called the Madrid Protocol, which we always thought sounds like a Jason Bourne movie. The third phase of the application process is examination and opposition. So after you file, you wait. But how long do you wait? The U.S. Trademark Office website says it is now examining applications filed 5 to 6 months ago. We've seen it be longer, up to 10 months. Sometimes it's been as short as 4 months. So let's assume 6 to 10 months before you hear back on your application. This is not, I should add, not like registering your car or for classes in college. It's an actual examination process, and the Trademark Office can refuse your application. The trademark examiner might find the trademark is too close to someone else's trademark that's been registered or previously filed and still pending. The examiner may decide that your trademark is too descriptive or generic to be a trademark, or doesn't function as a trademark, as the terminology goes. The examiner may also require amendments or request additional information about your application. Now, even if the examiner refuses the application, you do have a chance to respond and offer arguments and reasons why the mark should be registered. Now, getting past the examiner is not the only step in the process. Someone else may have a problem with your application and oppose your application when it is published for opposition. Oppositions can sometimes take a while, but often they resolve by agreement. The last step in the process is registration and maintenance. If your application gets through the process, the U.S. Trademark Office will issue a registration certificate. At that point, you can use the R with a circle around it, sometimes called the trademark registration symbol or the circle R that you see next to trademarks. If there are no refusals and no oppositions, the whole process can take less than a year, but usually not much less than that, and often more, especially if the trademark is not being used when the application is filed. To maintain the trademark registration, you do need to submit periodic filings every so many years with proof that you're using the trademark. We'll include a link in the description to the U.S. Trademark Office website that explains that part of the process. If you like this kind of stuff, you can like this video and subscribe to our channel. And you can also sign up for the newsletter in the link in the description. Even if you don't like trademark and franchise law, you can enjoy the occasional pictures of our canine law clerk at work and our regular trivia questions. We hope you enjoy.